You can represent yourself in court. That's the simple answer. The legal system gives you that right, and it even has a name for it: pro se representation. It sounds impressive, almost like a badge of independence. After all, who knows your story better than you? You were there. You lived it. You know the facts inside and out, so why not step up and argue your own case? The idea is tempting, especially if you've seen countless shows where someone storms into the courtroom and delivers a passionate speech that wins the day. But while the law does allow it, the reality is much more complicated than what you've imagined from a drama series or a movie. The reason you can represent yourself goes back to something deeply rooted in the legal system: the right to have your voice heard. Courts are open to everyone, not just lawyers. Justice isn't supposed to be reserved for people who can afford expensive attorneys. So, if you want to stand before a judge and make your case, the system gives you that chance. You won't be dragged out of the courtroom for trying. In fact, there's an entire infrastructure in place to handle self-represented individuals. Judges know they'll see people who choose to represent themselves, and clerks are used to receiving documents from people who aren't trained in the law. The door is open, but just because the door is open doesn't mean what's waiting on the other side is easy to deal with. Think about this: representing yourself in court isn't like telling your story to a friend. It's telling your story within the strictest framework you can imagine. The law has rules, and then it has rules about rules. There's a reason lawyers go through years of school, pass brutal exams, and then spend their careers still learning. The court expects certain formats, filings, and deadlines. Every motion, every document has to be in the right place at the right time, or it could be thrown out without the judge even reading it. Yes, you have the right to file it yourself, but if you don't know how, your right doesn't take you very far. Still, some people choose this path. Sometimes it's out of necessity. Lawyers can be expensive, and not everyone has the resources to hire one. In that situation, representing yourself feels empowering. You think, I'll fight my own battle. I'll tell my own story. I don't need anyone else speaking for me. And at the core, that's what pro se means: the right to stand on your own 2 feet and present your side. That's powerful. It's part of the freedom baked into the justice system. So yes, you can represent yourself in court. The law doesn't stop you. In fact, it welcomes you. But what the law doesn't do is guarantee that you'll succeed. It gives you a seat at the table, but it doesn't hand you the tools to win the game. That's something you have to consider carefully before you walk into a courtroom alone. Courtrooms can look simple from the outside: 2 people, a judge, maybe a jury, and an argument about who's right and who's wrong. But beneath that surface is an incredibly complex structure of rules and procedures, and those rules are what decide whether your case survives or collapses. This is why representing yourself in court can be so dangerous. The biggest threat isn't always the strength of the other side's argument. It's the landmines buried in the system that you don't even know exist until you step on one. When lawyers talk about procedure, they're referring to the step-by-step framework that controls every move inside a case. It's like a chess game, but instead of just learning how the pieces move, you also need to memorize thousands of variations, strategies, and hidden traps. Miss a step and you're out of the game. For example, there are strict timelines for when documents must be filed. Miss a deadline by even a single day, and the judge can throw out your motion without a second glance. File paperwork in the wrong format, and the clerk might reject it before it even reaches the judge's desk. Forget to serve the other side properly. The whole filing could be considered invalid. These are not small technicalities. They are the difference between having your case heard or losing it before it even begins. Then there are the rules of evidence. These govern what information the judge or jury is even allowed to hear. You might think you can walk into court with photos, texts or witness statements. But unless you know how to properly authenticate and present that evidence, the other side can object and get it thrown out. Imagine telling your whole story only to have the most important piece of proof silenced because you didn't follow a rule you didn't even know existed. Lawyers spend years learning how to admit evidence correctly because it's one of the most decisive parts of a trial. A single objection can erase your strongest point if you don't know how to respond. Another danger is underestimating the language of the law. It isn't just English, it's legal English. Words that seem simple in ordinary life take on highly technical meanings in court. A motion, a discovery, or summary judgment might sound straightforward, but each one has layers of complexity. Using the wrong term or misunderstanding a phrase could lead to arguments that make no sense legally, even if they sound convincing to you. Judges and opposing attorneys will immediately notice the gaps in your understanding, and it can cost you credibility before you've even made your real point. What makes this so dangerous is that mistakes in court are rarely forgiven. In everyday life, if you misspeak, you can explain yourself and try again. In court, a mistake can permanently close off an argument or even end your entire case. And once that door shuts, there's usually no going back. Appeals exist, but they are even more complex and often only review whether the rules were followed, not whether the outcome felt fair. So yes, you have the right to represent yourself, but the danger lies in thinking that right makes you immune to the consequences of errors. The courtroom is a battlefield where every step, every word, and every piece of paper matters. Without the training to navigate that landscape, you're not just walking into a fight. You're walking into a maze full of traps you don't even see until it's too late. When people imagine stepping into a courtroom without a lawyer, they often picture a judge patiently listening, gently correcting mistakes, maybe even offering helpful hints along the way. It feels comforting to believe that if you get something wrong, the judge will step in and set you straight. But that's not how the system works. Judges are not your coaches, they are not your guides, and they certainly aren't there to hold your hand. Their role is to remain neutral, to act as referees between both sides, and to make sure the law is followed. That means if you represent yourself, you are held to the same standards as the attorney on the other side, no matter how much training or experience you do or don't have. A judge's job is to enforce fairness between parties, not to create fairness for you. If the opposing side has a lawyer and you don't, the judge isn't going to tilt the scales to balance things out. In fact, they legally can't. If they were to give you special treatment, say, allowing you to bend a deadline, overlooking a filing error, or explaining how to respond to an objection, that would compromise their neutrality. Judges can't appear biased, so they apply the rules equally, whether you're a seasoned trial attorney or a first-timer who's never set foot in a courtroom before. That means your lack of knowledge becomes your responsibility. And let's be clear, judges don't have time to babysit. Court dockets are crowded, schedules are tight, and patience is thin. If you waste time fumbling through papers, making irrelevant arguments, or asking basic questions that you should have researched beforehand, it reflects poorly on you. You may think you're just figuring it out as you go, but from the judge's perspective, you're dragging the process down and wasting valuable time. That frustration can silently influence the way they view your credibility. Judges may not say it outright, but a disorganized, unprepared party comes across as less trustworthy. Even when a judge does explain something, it's rarely the kind of detailed guidance you might hope for. At best, they'll tell you the bare minimum, that's not admissible, or that motion isn't proper, without breaking down how you should fix it. Why? Because their role isn't to teach law, it's to apply it. If you don't know how to respond, that's your problem to solve. This creates an illusion for many people who represent themselves. They believe the judge will recognize that they're just a regular person and take it easy on them. But the truth is harsher. Judges often expect self-represented individuals to over-prepare, not under-prepare. They know you don't have the same training as an attorney, but they also know that fairness requires you to play by the same rules. And in some cases, judges are actually harder on people representing themselves, because a messy case can slow everything down and cause bigger problems for the court system. So when you walk into a courtroom alone, don't expect the judge to be your safety net. They aren't there to catch you when you fall. They'll let you stumble, they'll let you trip over the rules, and they'll let you face the consequences, because their job is not to protect you, it's to protect the integrity of the process. If you misunderstand that, you may be in for a painful lesson. The judge is not your ally, no matter how kind or patient they might seem on the surface. Walking into a courtroom against a trained lawyer when you have no legal background is like stepping into a boxing ring against a professional fighter after watching a few YouTube tutorials on how to throw a punch. On paper, you both have the same opportunity. You get to present your case, they get to present theirs. But in reality, the experience gap is enormous. Lawyers are trained for years to do one thing: navigate the legal system and advocate effectively for their clients. When you choose to represent yourself, you're facing someone who knows every corner of that battlefield, while you're still trying to figure out which way to hold the map. Think about what lawyers actually do. They don't just know the laws, they know how to use those laws strategically. They understand how to phrase questions to witnesses so the answers support their argument. They know how to object at just the right time to stop damaging testimony from being heard. They know how to interpret evidence rules so that their side gets their documents in while yours might get excluded. Every single step of a case has strategies attached to it, and attorneys spend years sharpening those tools. By comparison, when you're representing yourself, you may not even be aware that these strategies exist, let alone know how to use them. It's not just about knowledge, it's also about speed. Lawyers can think on their feet. If a witness says something unexpected, they immediately know whether to challenge it, how to impeach the credibility, or how to spin it in their favor. If the judge asks a tough legal question, they can reference a statute, a precedent, or a case ruling almost instantly. Meanwhile, if you're representing yourself, you may need time to think, flip through notes, or simply admit you don't know the answer. And in a courtroom, hesitation can be costly. Every pause, every ooh. Every slip communicates to the judge and jury that you aren't prepared, even if your case has merit. Another huge factor is credibility. Judges and juries naturally expect lawyers to know what they are doing. When an attorney stands up, there's an automatic assumption of authority. When you stand up alone, you don't get that same benefit of the doubt. You have to work twice as hard to earn credibility, and one small mistake can erase it. A poorly worded argument, a misunderstanding of the rules, or a failure to object at the right time all paint a picture of someone who isn't equipped to handle the fight. And once credibility is lost, even your strongest points may not carry the weight they deserve. What many people don't realize is that lawyers don't just fight cases, they anticipate them. They can see several moves ahead. While you're focused on explaining why you're right, the opposing lawyer may already be setting traps for your argument, preparing motions to block your evidence, or planning closing statements that dismantle your points before you even make them. That's the difference between training and guessing, so when you decide to represent yourself, understand the imbalance. It isn't just you versus another person. It's you versus years of specialized training, endless courtroom experience, and an opponent who knows how to use the rules like weapons. You may walk into that room confident, but confidence alone doesn't win a fight. Preparation, strategy, and expertise do. And when you're standing across from someone who's mastered all three, the odds are stacked heavily against you. There are situations where representing yourself in court can make sense, and it usually comes down to the size and seriousness of the case. Not every dispute is a life or death legal battle with years of consequences attached to it. Sometimes the stakes are smaller, the process is simpler, and the risks are low enough that hiring a lawyer might feel unnecessary. In those moments, standing on your own might actually be practical. One common example is small claims court. These courts are designed specifically for everyday disputes. Maybe your landlord refused to return your security deposit, or a contractor didn't finish the work you paid for, or you loaned someone money and they never paid you back. In cases like these, the dollar amounts are usually limited by law. The procedures are streamlined and the environment is more relaxed. Judges in small claims courts often expect people to represent themselves, and the rules are simplified so the process doesn't overwhelm non-lawyers. In this setting, showing up with your documents, telling your story clearly, and presenting evidence like receipts or photos can be enough. Another scenario where representing yourself might make sense is traffic court. If you're fighting a speeding ticket or a minor violation, you don't necessarily need an attorney to stand beside you. These cases are often straightforward, and the potential penalties are limited, usually fines, points on your license, maybe traffic school. While having a lawyer could improve your odds, the cost of hiring one might exceed the penalty you're trying to avoid. In that case, it's logical to handle it on your own, especially if you're prepared to present your side calmly and respectfully. There are also situations where hiring a lawyer simply isn't financially realistic. Attorneys are expensive, and if the case involves a small amount of money or a relatively minor issue, the legal fees might be greater than the value of the case itself. Imagine paying a lawyer thousands of dollars to recover a few $100s in damages. It just doesn't add up. In those cases, representing yourself may not only be the best option, it may be the only option. That said, even in these smaller cases, preparation is key. Walking in unprepared can still cost you, even if the stakes are relatively low. You still need to understand the basics: how to file paperwork correctly, how to organize your evidence, how to speak to the judge respectfully, and how to stay focused on the facts rather than emotions. The judge doesn't want a long emotional speech about how unfairly you were treated. They want the relevant facts that apply to the law. If you can discipline yourself to stick to the essentials, you may do just fine without a lawyer. So yes, there are times when representing yourself is not only allowed but also reasonable. The key is to recognize when the risk is manageable. If the case involves a small dispute, minor consequences, or limited financial exposure, you might decide that hiring a lawyer simply isn't worth it. In those moments, your right to represent yourself becomes a practical tool rather than a dangerous gamble. But always keep in mind that even in small cases, preparation is everything. Walk in organized, informed, and ready, and you give yourself the best possible chance to succeed without professional help. When the stakes are high, representing yourself in court shifts from being risky to being outright dangerous. There's a line where the consequences of losing are so serious that going in without an attorney is like playing with fire. Criminal charges, custody battles, and major financial disputes fall into this category. These are not small claims situations or traffic tickets. These are cases that can affect your freedom, your family, or your future for years to come. When that kind of weight is on the line, the risks of self-representation are too great to ignore. Take criminal cases, for example. If you are charged with a crime, the state is bringing its full resources against you, prosecutors, investigators, and a justice system built to enforce the law aggressively. The consequences aren't just fines, they could be probation, jail, or prison. In those circumstances, you're not just fighting for money or property, you're fighting for your liberty. Representing yourself in such a case is like trying to defuse a bomb after watching a tutorial video. You might understand the basics, but the margin for error is almost non-existent, and one mistake could cost you everything. Family law cases, particularly custody disputes, are another area where the stakes are too high to risk going alone. These cases are emotionally charged, legally complex, and deeply impactful. The outcome determines where your children live, who makes decisions about their future, and how their lives unfold. Judges making these decisions expect clear, legally sound arguments backed by evidence, not emotional outbursts or disorganized presentations. If you don't know how to frame your position legally, the other side's attorney will, and the court will be far more inclined to side with the person who presents a structured, rule-based case. Then there are high-dollar civil disputes, lawsuits involving contracts, property, or significant damages. These cases often involve thick stacks of documents, complicated legal theories, and expert witnesses. The financial consequences can be devastating. Lose a case like this, and you might be on the hook for tens of thousands of dollars, maybe more. Without an attorney to navigate those complexities, you're essentially betting your financial stability on your ability to learn the law overnight. That's not a bet most people should make. The bottom line is this: when a case has long-term consequences, the cost of losing far outweighs the cost of hiring professional help. Lawyers aren't cheap, but neither are prison sentences, custody losses, or crippling financial judgments. In high-stakes cases, a good attorney isn't a luxury, they're a necessity. They know the system, they know how to protect your rights, and they know how to build a strategy that gives you the best chance at a fair outcome. So while the law gives you the right to represent yourself, it also gives you the choice to hire someone who knows the battlefield far better than you ever could. And when your freedom, your children, or your financial future is at stake, that choice isn't really a choice at all. It's common sense. In those moments, representing yourself isn't brave, it's reckless.